call on Government Order of the Day number 3.
Weathertight Homes Resolution Services Amendment Bill, second reading.
Speaker.
The Honourable Nathan Guy.
Speaker, I move that the Weathertight Homes Resolution Services Amendment Bill be now read a second time. I would like to take this opportunity to thank my colleague Scott Simpson for his work in chairing the Local Government and Environment Committee, and of course the rest of the committee for its consideration on this very important bill. I believe they've brought some well thought out recommendations back to the House that I think will improve the overall clarity of this bill. I'm proud to commend this bill and the Select Committee amendments to the House. Mr Speaker, I'd like to briefly reiterate the key changes proposed by this bill. The bill is a package of 3 important areas of change to make sure that the options available to homeowners under the Weathertight Homes Resolution Services Act continues to work effectively. In particular, the bill amends some of the provisions around the financial assistance package, FAP scheme under the Act that focuses on getting leaky homes repaired. Instead of homeowners having to go down the track of litigation, they can apply for funding from the government to contribute to the overall repair costs. 2 of the main changes are aimed at clarifying the way that eligibility under the Act is interpreted. First, so there is no doubt about the validity of some of the criteria that homeowners have to meet to qualify for the FAP. The bill lifts some of the contribution criteria out of a Gazette notice and puts them into the Act. It is crucial that these 2 criteria work to ensure that territorial authorities continue to participate in the FAP. Another main area of change in the bill is deeming some people eligible if they had previously had claims held to be ineligible under the Act because of the way that courts and tribunals have interpreted the 10-year period from the date that a house was indeed built. These amendments mean that around 70 homeowners who might have had eligible claims if their cases had been decided using the interpretation that the Supreme Court used in its decision in Osborne versus Auckland Council will have their claims deemed eligible. If they meet the other eligibility criteria in the Act, those people can access the dispute resolution services and the FAP under the Act. Finally, the bill makes some changes to the expiry of the FAP. Under the Act, claimants need to have issued a notice to proceed by 23 July 2016. There are several steps required before a person can issue a notice to proceed, and it can take varying amounts of time depending on the circumstances of the claim. So the bill includes a provision to enable people who are actively working their way through the process to be able to continue with their claim after the 23rd of July 2016 and not be locked out of this process. The Select Committee got some very helpful submissions which raise issues about whether some of the drafting was sufficiently clear for claimants and territorial authorities. Particular areas of concern were around the exact requirements for FAP claimants to meet the contribution criteria once they are moved into the Act, and also potential for confusion arising from the various dates that code compliance certificates can be issued. I would like to thank the people and organisations who took the time to make very important submissions and express their views in front of the Select Committee. The Select Committee has recommended a number of improvements and clarifications to the drafting, which I believe will address the concerns that were raised and better achieve the government's policy intent. I'd also like to take an opportunity to outline some of the key changes that the Select Committee recommended. Submitters were concerned that just lifting 2 of the contribution criteria out of the Gazette notice into the Act would result in loss of clarity as to how the criteria interrelate and exactly which criteria a claimant would need to satisfy. The committee therefore recommended a standalone provision which groups all the related matters to do with being a qualifying claimant into one section. It also recommended inserting a new provision making it clear that in order to receive a contribution from a participating territorial authority, a claimant must first have qualified for a Crown contribution. Submitters also raised concerns that homeowners whose claims have been ruled ineligible because of the interpretation of built applying by courts and tribunals before the Osborne decision and who had repaired their homes subsequently would not be able to access the FAP even though they would have been able to meet the contribution criteria at the time their claim was held to be ineligible. It wasn't the intention that those people should be excluded, so the bill has been amended to allow for this. Other key recommendations of the committee were that the issues raised around the timing of the issuing of Code of Compliance certificates. Historically, there has been considerable variability around when a territorial authority issues Code Compliance certificates. To make sure that the bill only applies to those in similar situations to the homeowners in the Osborne case, the committee recommended amendments to make it clear that a Code Compliance certificate must have been issued by the date of eligibility decision and in any event before the 1st of January 2012, which is in line with the rest of the Act. I support all of the recommendations of the Select Committee, and I have no doubt that the bill has been enhanced through this very important process. Mr. Speaker, I commend this bill to the House.